Hello and welcome to this webinar on residential leasehold and subletting. I have with me James Compton, a solicitor and partner with the firm of Compton and Partners. James, I own a flat. It's in a block, and I live elsewhere. I haven't had it for too long, but I'm interested in a steady income. Okay. I'm keen on letting it out. I'm wondering what are the implications of doing so.
First thing to do is to look at the terms of your lease. So bringing it back to basics, the lease is an agreement between you and your landlord, and there's various terms and conditions contained in your lease, one of which is probably going to concern subletting. And there's various different types of covenants that you might find concerning subletting. First of which is that you are not allowed to sublet without prior consent of your landlord. Normally that covenant will then say that the consent can't be unreasonably withheld or delayed, but even if that unreasonably withheld or delayed wording isn't included, then it is implied under section 19 of the Landlord and Tenant Act 1987. Another alternative covenant that might be in there is that you are allowed to sublet, but on certain conditions. Like, for example, the subtenant must enter into a direct covenant with the landlord adhering to the terms of the lease, or that the letting must only be by way of an assured short-hold tenancy for, say, more than 3 years, or that you're not allowed to sublet to a company. The third alternative, perhaps there'll be an absolute prohibition on subletting, which would be a bit difficult if you've acquired the property, but perhaps bring that up with your conveyancer. But you sometimes do find absolute prohibitions in some upmarket blocks where they want to retain control of who's actually occupying the flats. And then finally it might be that there's no reference to any subletting in the lease, although be careful, because you don't have to just look for the word subletting. If there's a covenant restricting dispositions, for example, then that does also refer to subletting.
Okay, I'm wondering, once I've sublet, do I have to tell the landlord?
Normally, well, it depends on the covenant in your lease. If you've got a covenant that you have to get the landlord's consent, then prior to subletting, yes, you should you should ask the landlord for consent. But most types of covenants will say that the consent can't be unreasonably withheld or delayed. And there's the Landlord and Tenant Act 1988, which actually puts a statutory obligation on the landlord to give consent within a reasonable time, to serve on the tenant written notice of the landlord's decision regarding the sublet, and if the consent is given on conditions, to state the conditions, and if the consent is refused, to state the reasons for refusal. So I guess flowing from that, and probably quite pertinent if you're wanting to get a tenant in there, is what is a reasonable timescale and what are reasonable reasons to refuse consent. What is a reasonable timescale? Difficult to tell. A lot of the cases involve commercial subletting, but there is a case that suggests 28 days from when you send the landlord your application for consent, and what are reasonable reasons for the landlord to refuse. But in the context of residential letting, it's actually quite difficult to find a real reason as to why a landlord would refuse consent. If you look at, again, the commercial alienation cases, they all concern whether or not there's a damage to the reversionary interest, the financial standing of the tenant. But in the context of residential, I think it's quite tough for a landlord to refuse.
Okay, so I apply to the landlord because that's what may well be required by the lease.
Yep.
I can't let out the flat without the landlord's consent, and the landlord cannot willfully or unreasonably withhold consent.
Yeah.
But I anticipate that even if they're prepared to give consent, they'll want some money in return. And do I have any rights in that regard?
Well, certainly. I mean, normally if you have a provision where consent is required, the landlord is going to want a formal licence. Again, there's a big question mark as to the extent of that licence. Unless the clause specifically refers to a deed, then arguably just a simple letter is written. But often in practice you find that landlords will get the solicitors involved and you have to pay for a licence to sublet. and there's fees involved. But the key point to note is that those fees charged in respect to that licence have to be reasonable. And the reason is that those fees are what you call an administration charge under the Common Hold and Leasehold Reform Act 2002, and which stipulates that administration charges have to be reasonable. So if you do get a landlord that is, you feel, trying to charge excessive fees in relation to that licence, you do have the option to apply to the first tier property tribunal to have those fees determined. Although the practical difficulty you're going to face is if you want to get a tenant in there, how far are you going to push it? Obviously applying to the tribunal is going to delay matters, and you might incur costs in doing so as well. So that's a practical consideration.
Okay. Suppose I do sublet the flat, but I mean, thanks, you've told me now I should check the lease, but suppose, let's say the scenario, I had sublet the flat and I hadn't got the consent required as required under the terms of the lease. What would be the repercussions if the landlord was prepared to give me consent, but retrospectively, but in return that I would have to pay some money to him?
Well, the concept of retrospective consent is a bit interesting because the breach has occurred. It's a one-off breach. You didn't get consent, and unless you've got a time machine, which no doubt you won't have, you won't be able to go back and alter that. So, technically speaking, there's no real such thing as retrospective consent, but certainly it is often the case that leaseholders, when they find out about the fact that they should have got consent, might want to approach the landlord to get some form of comfort that they won't be going after them for potential breach of the lease. But again, the landlord most probably will seek fees in relation to that licence or retrospective licence or retrospective consent. Again, they do have to be reasonable because they are an administration charge. The landlord might try to use it in the context of forfeiture proceedings, but the argument, if a landlord does seek to bring in any type of damages claim or forfeiture claim, is that the landlord can't unreasonably withhold consent in the first place. So the landlord should have good reason for not providing their consent if they are being quite aggressive about it. But the ultimate sanction, if you do breach your lease, is forfeiture.
Oh well, my ears prick up when you mention the word forfeiture, because my understanding is that means I lose the flat. What are the steps to me losing that flat? I mean, is it easy for the landlord to get my flat back if I didn't get consent to sublet and they're not prepared to give me consent retrospectively?
Fortunately, since the 2002 Act, it used to be the case that a landlord could serve what you'd call a Section 146 notice against the leaseholder if they were in breach. But since the 2002 Act, the landlord would first have to apply to the First Tier Property Tribunal under Section 168 of the Common Hold and Leasehold Reform Act for a determination that the leaseholder is in fact in breach. Unless, of course, the leaseholder admits it. So the best thing to do if you're a leaseholder is to deny. But if it is the case that the landlord does want to take it further, they will have to apply to the First Tier Property Tribunal first. Then once that determination is obtained, if it is, then 14 days after the determination, a Section 146 notice can then be served by the landlord. The leaseholder then has a reasonable amount of time in which to rectify the breach. But yes, if the breach still remains unremedied, then possession proceedings or forfeiture action could then be taken. And the court does have wide discretion, though, with regards to forfeiture. And you'd think that if it is a minor breach, you should be okay. But there is potentially sanctions against you in terms of forfeiture for a breach.
Okay, well, I understand the position a lot more now. But James, finally, I wonder if there are 3 points that you could tell us that our listeners can take away.
Sure. So I think the key point is that before subletting, you should check the provisions of your lease, or if you are going to acquire a property that you intend to sublet, get the conveyancer to check to make sure there's, for example, not an absolute prohibition, or if there is consent required, that you make sure you put that in place as soon as possible. If consent is required, then there is a duty on the landlord not to unreasonably withhold or delay, and even the Landlord and Tenant Act 1988 states that damages are payable if that statutory duty is breached. So it's legislation that does have teeth. And then finally, all landlord's fees relating to the subletting, whether it be a registration fee or the cost for a licence, have to be reasonable because they are an administration charge.
Thank you. Thank you very much, James, for enlightening us about residential leasehold and subletting, and thank you very much for listening.